Good morning, this is John Lynch of Lynch Solicitors in Clonmel, County Tipperary, with another one of our COVID-19 videos. This morning I'd like to talk to you about divorce and just kind of a broad discussion on divorce since it started or since its inception. Now, I suppose you can't talk about divorce without also talking about separation agreements or judicial separation and also in fact nullity. So when you look at divorce in the context of judicial separation or separation agreements, where you're separating historically or when it started, when you separate, you can either do a written agreement, which is a separation agreement, which is a form of legally binding document that can be signed with the assistance of mediation and or solicitors agreeing the terms. You sign that off, now you've got a legally binding separation. You can also, if you, again, when I say historically, I mean up to quite recently, and you would also deal or could also deal with it by way of judicial separation. And that's where you can't reach an agreement with the other party, that in those circumstances you can apply to the court for a judicial separation. And a judicial separation is just a legally or a court mandated agreement. Now, in those circumstances, you then would, the essential difference between doing a separation agreement or a judicial separation, the essential difference between that and the divorce is the fact that you can't remarry after a separation agreement and or after judicial separation unless you get your divorce. So in Ireland, we had this situation where we had this kind of hybrid type of application that you could make for judicial separation. In recent times, i.e. literally within the last number of months, at the end of 2019, you had the whole change that came about, which meant that they shortened the time frame for a divorce. Once the divorce time frame was shortened to 2 years, from 4 years, you're now into what is potentially a changing environment insofar as people will more than likely go straight to a divorce application rather than go through a judicial separation application and having two applications, if you like. Now, it still might be the case that, for example, what used to be the practice prior to this was that what you would do is you'd make an application for your judicial separation, and by and large, by the time you would have reached the end of that process, you may very well be within shouting distance of the 4-year requirement for a divorce, and therefore in quite a number of cases we would have simply substituted the paperwork, and instead of getting a judicial order, separation orders, you get divorce orders. But again, time will tell as to whether or not people will still avail of judicial separation rather than of divorce. The other one is nullity. And nullity is where the marriage never existed in the first place as far as the law is concerned. And nullity, without going into the nitty-gritty of it, can either be that there was a defect in the marriage contract or the requirements, legal requirements for a marriage, and therefore there was never a marriage, and or one of the parties to the marriage didn't consent to it or had a disability. There were a number of different headings under which you could make an application for nullity. I think it's safe to say that over the last number of years, the amount of nullity applications has dwindled by reason of the fact that if you deal with a nullity application, you still have to satisfy the court that provision is being made for all of the dependent parties of the marriage that has been dissolved, and therefore it's similar to a divorce situation. Now, the other important point that has been kind of clarified over the last number of years is the finality of divorce. In other words, that once you have your divorce or once you've done your separation agreement or judicial separation, that's final. Now, the courts have said yes, the courts should strive for finality. However, you have to bear in mind, or one should bear in mind, that it's not always possible to get finality. and particularly when you're dealing with something like maintenance, which can change over the years. For children, that is, that as they grow older, there may be more or higher requirement for maintenance payments. The other area, broad area, that there was a kind of a clarification on over the last 30 years was the whole area of what we call second bite of the cherry. And that's a rather inelegant phrase, dealt with a situation where parties might have separated, entered into a separation agreement, gone their separate ways, divided assets 50-50, and then so many years later come back in looking for a divorce or judicial separation, and the question arose as to whether or not the circumstances could be revisited and looked at again, and whether or not the whole proper provision requirement would come to bear a second time out. Initially, and very much still the case, a lot of these were very old separation agreements, and the courts had very little hesitation in revisiting them, looking at the current circumstances of the parties and making further provision. The more contentious one was that where somebody would get a fairly recent judicial separation and do a 50-50 split on it, that in those circumstances there were initially, prior to the Supreme Court making a determination, there were kind of two schools of thought. One was, if you divided everything up equally and it was reasonable and fair, that should be the end of the matter. The other school of thought was, no, the court retains an inherent jurisdiction to look at everything and apply proper provision criteria and could revisit the situation. The Supreme Court handed down a decision that basically D&D is called, for anybody who wants to go and have a look at it, handed down this decision that basically said, no, by and large, unless there are exceptional circumstances, as a general rule, you don't revisit. Now, that, of course, meant that, if you like, the second bite wasn't available to people. So if you did a judicial separation, that was the end of the matter. Now, bear in mind, of course, that if we have, or if it proves to be the case that judicial separation is no longer, the first port of call, and that divorce becomes the main show in town, that under those circumstances, the whole idea of revisiting court orders, even though there is provision for it within the legislation, the whole idea of revisiting court orders is something that the courts are quite reluctant to do unless there are exceptional circumstances where somebody suffers from a disability, or where there was a certain amount of fraud, or where something was concealed or something like that. Under those circumstances, the court will. But as a general rule, and in a very general way, it's unlikely that the court will revisit. And the last thing that kind of got a little bit of clarity over the last number of years was the status of inherited assets. And again, the scenario here is that the courts take the view, and it seems to be the practical view that's taken, that where there isn't enough to go around, where the assets aren't really very ample, there isn't sufficient assets there, that under those circumstances, everything is treated equally. There's no particular emphasis put on inherited assets. However, where there is enough to go around, and if you like, that everybody is looked after within the assets that are in the marriage, where assets are inherited, they are treated differently as far as the courts are concerned, in circumstances where you have over and above what are the requirements of the parties. So that has been a development over the last number of years that has certainly clarified things. So just to sum up, I think divorce and the change to 2 years is going to have a significant impact on whether or not people go for judicial separation or separation agreements. I think the fact that it's reasonably well established now that a second bite is not an available option means that it'll be a once-off in dealing with divorce, with the exception, of course, of maintenance, which is something that can change at any stage. Again, thank you very much. This is John Lynch of Lynch Solicitors.